In memory of the three girls who so tragically died 2 years ago, and to mark our profound respect for the courage and resilience of all those who were physically and psychologically injured as a consequence of what occurred at the Hart Space on the 29th of July 2024, along with their families, please join me in standing for a minute's silence. Thank you. Today marks the anniversary of the opening of phase one of this inquiry, a notable coincidence which leads me to express my profound thanks yet again, but with undimmed force, for the exceptional patience and encouragement on the part of the surviving victims and their families, but also for the high level of cooperation by all the core participants and those who have been supporting and assisting them. In a similar vein, I have been keenly aware of the consistent and exceptional hard work on the part of the inquiry team. This impressive spirit of collaboration has put us in the position of having a real chance of fulfilling our commitment of completing the entire inquiry process within 2 years. There have been 3 departures from the inquiry team that I want to mark. Caroline Featherstone, the solicitor to the inquiry, has retired. Kate Anderson, the secretary to the inquiry, has, for the most understandable of reasons, moved on to a new role. Their contribution to phase one and the help that Kate Anderson has given to the preparation for phase two has been quite exceptional. I wish publicly to acknowledge the truly significant role they have both played. They have been replaced, respectively, by Ross Howarth and Russell Knight as solicitor and secretary to the inquiry. I am delighted they have both accepted these roles. John Goss, one of the junior counsel to the inquiry, also departs today to fulfil professional commitments to which I was fully aware he was bound prior to our commencing phase one. He has made an enormous contribution for which he has my considerable thanks. I have been exceptionally pleased with the strong response by the government to the phase one report and our recommendations. The Home Secretary, in her introduction to the response, stated last week, and I quote, "The findings of the Southport inquiry report were rightly unsparing. The perpetrator came into contact with the state on countless occasions in the years leading up to the attack. Failures in both systems and culture meant multiple opportunities were missed to stop this atrocity. That is unacceptable. I am clear that the inquiry must act as a turning point in honour of the victims, their families, and all affected, meaningful change must now follow. In keeping with that aim, we are accepting all the recommendations for central government in the Phase 1 report. My department is taking the lead on coordinating this work with support from the various departments that share responsibility for delivering against the recommendations. Our collective commitment to meeting the outcomes intended by Sir Adrian is absolute. We need to get this right, but I am clear about the need for urgency. The government will update on its progress ahead of Phase 2 of the inquiry concluding next year. Close quotations. The Home Secretary, therefore, accepted without equivocation that the fundamental risk posed by AR had been neither understood nor managed appropriately. With respect, I suggest this is a wholly promising reaction to the Phase 1 report, and we will monitor closely how this admirably expressed commitment unfolds. There is now a Home Office-led task force which is focusing on this critical area, a development about which Nicholas Moss, lead counsel to the inquiry, will provide more details in a moment. But this is not just about central government. I need to emphasise that across the board, there have been extremely positive responses to the Phase 1 recommendations. A little later today, a summary will be provided of the up-to-date position in this regard, and Mr. Moss will explain the steps we are intending to take to monitor the progress to the Phase 1 recommendations and to call defaulters to account, something which I hope will be wholly unnecessary. Furthermore, not least because of the events 2 years ago, there has been significant activity on the part of a number of individuals and bodies as regards the risks posed by this violence-fixated cohort, and we will seek to ensure that we do not simply replicate, repeat, or interfere with steps that are being suggested or taken by others, whilst at all times recognising that we are in no sense bound by the conclusions of any of them. These include the reports by Lord Anderson and Jonathan Hall, King's Counsel, respectively the former and present independent reviewers of terrorism legislation, the report of the Independent Commission on UK Counter-Terrorism Law, Policy and Practice, and the report from the Home Affairs Committee. From these, we find, for instance, clear support for Lord Anderson's suggested approach for PREVENT to be connected to a broader safeguarding violence reduction system. We should not underestimate, however, the challenges of adapting existing arrangements, whether multi-agency or otherwise, to accommodate the management of those fixated with violence, particularly given the existing considerable pressures on the PREVENT and other programmes. Additionally, I note there is ongoing work by various other bodies, including by His Majesty's Inspectorate of Constabulary and Fire and Rescue Services. Again, Mr. Moss will expand on these aspects. The strong and positive reaction to the Phase 1 report, as generously expressed by a wide range of interested bodies and individuals, has deepened my belief that as a society, we need, in the aftermath of events as devastating as the present, to reach a rapid understanding of what actually happened and why, which self-evidently was our objective in Phase 1, thereafter speedily identifying and then implementing the overarching changes necessarily to address effectively the fixation with violence on the part of a growing number of people, which is our task in phase 2. In a sentence, we must now, with the greatest care, but also at speed, do all we can to prevent a repetition of the events in Southport 2 years ago, which were, tragically, wholly avoidable. The victims and their families will be at the very centre of our work during phase 2, not least because they have the right to expect that we remain, as I hope will be the case, unwaveringly focused, efficient and effective in our work, and that we identify, wherever they exist, the changes of substance that must be made as to how we address those who have a dangerous preoccupation with significant violence. I want to emphasise at this point that my ambition is that the solutions we identify are practicable, readily enforceable, and proportionate. There is no point in coming up with complicated, labour-intensive new systems or adjustments to existing arrangements, only then to siphon resources away from organisations running existing vital programmes. We must strive to identify mechanisms and changes which do not impose unrealistic additional financial burdens on our already strained public resources. We must seek out ways of intervening which will be clearly understood by all involved and which can readily be applied. I consider it of particular importance that it is absolutely clear for the future where responsibility lies for monitoring and ensuring that the right action is taken, particularly when a number of different agencies are involved. Multi-agency working really must be effective in this context and not just an aspiration or a slogan. Our proposals at the end of this process, therefore, must offer a real prospect of effecting substantive change. I suspect that in pursuing that objective, outdated, and whether or not outdated, incompatible IT systems may yet prove to be one of the greatest challenges. All of that said, I am resolutely optimistic that between all of us, we are well placed to identify the causes of past failures, along with sensible and effective means of implementing real change. But the detail must await the evidence and submissions that the inquiry will hear starting in the early autumn. The evidence sessions will be spread over September, October and November, and if needed, early December. More than anything else, young people must be diverted from the thoughts and impulses which motivated AR in July 2024. We are confronted with a growing challenge from violence-fixated individuals who all too often are not acting out of an adherence to a particular ideology. Instead, the reasons for their interest in violence is various, and as a consequence, they can be extremely difficult to identify. All too often, they will be acting entirely alone, having spent endless hours in solitude, relentlessly online. The inquiry team has worked hard to identify a range of ways by which we will achieve a real level of understanding of this problem and the solutions to it. Mr. Moss will explain in a moment the extent and the detail of the mixed approach that we will take to the evidence. But before I hand over to him, I want to stress very shortly 4 limited aspects of what is to come. First, we are going to look closely at the themes that emerge from 6 case studies involving other individuals which bear at least some strong similarities to the position of AR. We anticipate these cases may reveal common patterns, along with gaps within and between the agencies such as existed in the present case, with the inevitable consequential missed opportunities. They will highlight a range of other systemic issues. I want to stress that we will not be reinvestigating those cases, nor will we be conducting separate inquiries into them. Instead, we will seek to identify lessons from others who have planned offending in similar circumstances. I need to stress that throughout Phase 2, the inquiry will refer to all of those 6 case studies by cipher. I have adopted this approach because the inquiry's focus is on the wider themes and issues that emerge from them, rather than the circumstances of any particular individual. It also reflects my desire, consistent with the approach we have taken in relation to AR, to avoid conferring further notoriety on those who have committed or contemplated acts of serious violence, and to minimise the risk of imitation. In relation to 2 of the case studies, A and B, I have made an anonymity order. That order has been made because there are significant issues concerning risk, and it would be inappropriate to identify those individuals or to provide details that could lead to their identities being revealed through what is often referred to as jigsaw identification. The media have been given notice of the terms of these restrictions, and the anonymity order is published on the inquiry's website. I therefore remind all those reporting on these proceedings that those restrictions must be respected fully and at all times. Mr. Moss will today name the remaining 4 individuals referred to as case studies C to F. But that will be the only time during the entirety of these proceedings when their names will be used. Thereafter, they will simply be referred to by their cipher. Accordingly, whilst the identities of case studies C to F are to be disclosed, I ask and encourage all editors, broadcasters and publishers not to name those individuals in their reporting. Instead, I would ask that the relevant cipher is used throughout, including when reference is first made to them. This request is not intended to limit reporting on the circumstances of those cases or the issues they raise. Rather, it is intended to reduce the risk of providing them with the notoriety they seek and to minimise the risk of imitation attacks. I am grateful for the constructive approach taken by the media during Phase 1, particularly in respecting our request not to publish AR's custody photograph. I urge that his image or his custody photograph is not used in the reporting of Phase 2 out of respect for the seriously adverse impact those 2 representations of his image have on the victims and their families. Returning to the ways in which we will receive evidence, secondly, there will be a series of thematic seminars with carefully selected experts who will be critical for our understanding of matters as diverse as the impact of the psychiatric and psychological makeup of the members of this violent cohort, the effectiveness in the present context of the PREVENT programme, the risk management structures that are available other than that provided by PREVENT, and the operation of our current offender management systems. We will look at the processes and procedures implemented in other countries to address these problems. We will consider the adverse influence of the online world, which is a particular and deep concern of mine, and we will reflect on the adequacy of our existing statutory and regulatory framework in this context. Third, we have issued 8 sets of highly detailed questionnaires nationwide, which I'm going to leave to Mr. Moss to explain to avoid duplication. But the results, which will be expertly analysed, could well be of truly significant interest. And fourth, we will call a wide range of witnesses to give what I'm going to describe as conventional evidence, which will be provided in response to the extensive Rule 9 witness statement requests issued by the inquiry over the last month or so. The scale of the task before us is therefore considerable, not least because the problem we have been asked to address is profound and cannot be solved by some easy, quick fix remedy. But we will do all in our power to provide a range of practical and enforceable solutions by the spring of next year when we deliver the Phase 2 report. Our core objective is to assist in bringing about real change, given the devastation that can be wrought by those fixated on violence in this way. The victims of AR's grotesque actions on the 29th of July 2024 deserve nothing less. That concludes my opening. We will now take just over a 15-minute break until 11:10, when Mr. Moss will provide CTI's opening. I'll rise. Mr. Moss, I'll leave you to choose an appropriate point in the opening for us to break for lunch.
Thank you, sir. May it please you, sir, the starting point for our Phase 2 work is and must be Elsie, Alice and Bibi, each of them murdered by AR and their family members. And it is children C1, C2, C3, C4, C5, C6, C7, C8, Leanne Lucas and Jonathan Hayes, each of whom were stabbed by AR and suffered severe psychological trauma. And it is children J, K, L, M, N, O, P, Q, R, S, T, U, V, W, and X, along with Heidi Little, who evaded physical injury, but also suffered severe psychological trauma. Phase 1 of this inquiry has established in necessary, but I regret in distressing detail, what happened both on the day these innocent victims were attacked, but also with the agencies involved with AR in the years that led up to it. The task now for Phase 2 of this inquiry is, in essence, to consider the present arrangements for violence-fixated individuals in the 4 topic areas set out in our Phase 2 terms of reference, to critically analyse their adequacy and to make effective and pragmatic recommendations to minimise the risk of any repeat of such an unimaginably dreadful attack in the future. With that in mind, in this opening, we're going to address 3 issues. First, an explanation of how the responses to the Phase 1 recommendations will be monitored in this Phase 2. Second, an update on the work that has already been done in Phase 2, in each of the areas you've already introduced, sir. So the case studies, the questionnaires, our planned seminars, and the remainder of the Phase 2 hearing programme of more conventional forms of evidence. And third, we will give an introduction to each of the 4 topics in the Phase 2 terms of reference. So I start, sir, with how the response to the Phase 1 recommendations will be monitored in Phase 2. So you made some 67 recommendations in your Phase 1 report. Of those, 10 were recommendations that wholly or in part raise matters that you said should be considered further in Phase 2. In your early meetings with the victims and in submissions, you have heard the importance that they rightly attribute to effective and speedy implementation of improvements in response to your recommendations. That is to say, the need for real, tangible change. They have stressed that they are well aware that there have been a multiplicity of recommendations from earlier atrocities. They have a perhaps understandable scepticism about the effectiveness of action taken in relation to public inquiry recommendations in the past. The sentiment that has been expressed to the inquiry is that lessons will be learned, and lessons have been said so often that it feels like a debased currency. So you have made clear that respecting both the proper remit of your powers and the delineation of responsibility between, on the one hand, an inquiry chair, and on the other hand, government and other bodies to whom recommendations are made, you wish to monitor closely the progress made towards effective implementation of your recommendations. Accordingly, between the 30th of April and the 5th of May this year, all of the departments and organisations to whom your Phase 1 recommendations were made were contacted by the inquiry. They were informed in clear terms that you will be taking that close interest in how the recommendations are considered and taken forward. An update was requested on your behalf within 6 weeks, setting out what work is currently being undertaken, requesting timescales for completion or implementation, and any foreseeable issues or matters on which progress was dependent. It is right that I should list publicly those contacted, which is as follows: Alder Hayes Children's NHS Foundation Trust, Amazon, their Care Quality Commission, the College of Policing, Counter-Terrorism Policing Headquarters, Counter-Terrorism Policing Northwest, the Department for Education, the Department for Health and Social Care, the Department for Science, Innovation and Technology, the Department for Transport, Greater Manchester Mental Health NHS Foundation Trust, who were, of course, responsible for the relevant forensic CAMS service, the Home Office, Lancashire Constabulary, Lancashire County Council, the Law Commission, Merseyside Police, the Ministry of Housing, Communities and Local Government, the Metropolitan Police, the National Police Chiefs Council, the National Ambulance Resilient Unit, whose functions have now in fact been taken over by the NHS Resilience Emergency Capabilities Unit, NHS England, the North West Ambulance Service and the Youth Justice Board. So I can't give the full details today, it would take too long, but I'm pleased to be able to update in the following general terms. First, there have been replies from every one of these organisations, and copies of the most relevant correspondence have been collated and were made available to the core participants earlier this week. Secondly, for the recipients of recommendations other than central government departments, so I'm pleased to be able to update that all of the recipients appear to be proceeding on the basis that they have accepted your recommendations and their focus is now on implementing them. Thirdly, as you have already referenced earlier this morning, the formal response of the government to the Phase 1 report was issued last week on the 2nd of July. And the Home Secretary makes clear that the government formally accepts each of the recommendations that are for central government to deliver. Importantly, however, beyond that, the Home Secretary has made clear that the government also agrees with all 67 recommendations. We understand that to mean that where the inquiry has made recommendations to bodies other than central government, the government positively supports the recommendations that you have made. On any view, central government's response to the Phase 1 report released last week is detailed, considered, and encouraging. As the response itself acknowledges, however, much work is still required. And as you've indicated, sir, the inquiry will be engaging very closely with the Home Office as the lead department in the weeks and months to come. Fourthly, sir, the responses from all other recipients are also, in broad summary, for the very most part, meaningful and engaging. May I just mention two recommendation recipients in particular. Firstly, CTPHQ, that's Counter-Terrorism Policing Headquarters, have provided a detailed response, but some of the detail in that response, for understandable reasons, relates to sensitive matters, and so a disclosable version is being prepared, and core participants will be provided with that as soon as practicable. They have been fully cooperative. And so recommendation 67 relates to the Law Commission, and core participants can be reassured that you, sir, have been liaising personally and directly with the Law Commission at a very senior level on that recommendation. Next steps on Phase 1 recommendations. The early signs are then encouraging. However, the inquiry will be writing to all of these organisations again next week, setting a deadline for a further update, which is likely to be Friday the 28th of August. All the organisations concerned, and I've listed them, should please note that following the first set of updates already given, the inquiry's intensity of scrutiny will be increasing for this second update. For some recommendation recipients, there will be targeted questions asking for more detail or assurance on points in their initial responses. And the inquiry will circulate these second updates to core participants, but it is also intended that they will be published on the inquiry's website in September, unless there are good public interest reasons not to do so. Looking beyond the second update stage at the end of August, you've set aside some time towards the end of the envisaged Phase 2 oral hearings at the end of November or possibly the start of December for calling for witness evidence, live witness evidence, from the organisations to whom Phase 1 recommendations have been made. Those hearing slots are in place so that you can hear in public transparently from any organisation whose response to Phase 1 recommendations appears in your judicial assessment to be falling short, whether in substance or in timeliness. Recipients of recommendations will therefore wish to bear that carefully in mind, we would suggest, and ensure that their responses continue to be detailed, meaningful, and candid, as they have been so far. As you have already observed, however, sir, it is hoped, of course, that this will be wholly unnecessary. Can I turn then to an update on the work that has already been done in Phase 2? I should start with core participants, if I may. Those to whom you have granted core participant status for Phase 2 are, first of all, of course, the parents of Alice, Bibi, and Elsie, the parents of the other child victims, and the 3 adult victims. Other core participants are Counter-Terrorism Policing Headquarters, the Crown Prosecution Service, the Department for Education, the Department of Health and Social Care, the Department for Science, Innovation and Technology, the Local Government Association, the Ministry of Justice, the National Crime Agency, NHS England, the Secretary of State for the Home Department, and the Youth Justice Board. So for good and understandable reasons, not all the advocates are present today for those core participants. So with your permission, sir, if I may, I will introduce them on a later occasion. I should, however, just mention that we are fortunate that Alex Jameson and Genevieve Woods have joined as junior counsel to the inquiry. 2 bodies sought core participant status, which you have decided not to grant. One of those has made further representations, and the existing core participants will be kept informed in that regard when you've made a decision on those further representations. Can I turn next, please, to witness statement requests under Rule 9 of the inquiry rules? Under Rule 9, the inquiry legal team has worked intensely on the programme of witness statement requests under that rule. The position we have reached is that the inquiry legal team has very nearly completed the requests to bodies and individuals that the inquiry itself has identified as being most likely to able to assist in phase 2. Needless to say, however, the door to others being requested to make witness statements is not closed. Those to whom we've already issued witness statement requests may well identify others who can assist. And may I stress that core participants may also identify others as well. However, in this first major phase of issuing Rule 9 requests, from the first request that was made on the 20th of May to this morning, the inquiry has issued some 69 requests for witness statements, and by the close of play on Friday of this week, the final 17 or so will have been issued. So some of those may be to several similar groups, for example, retailers, so the final number may be a little higher than 17. The requested return time for more straightforward witness statement requests is 2 weeks, extending to 4 weeks for the most complex, and so I'll come back to that. Some of these Rule 9 requests, particularly those to government departments, agencies, policing bodies and local government, cover more than one topic in the terms of reference. And within that category of the Rule 9 requests, the inquiry is now sent to the following. Firstly, the Home Office. They, in fact, have received one major Rule 9 request, but several smaller additional Rule 9 requests as well, with one more to follow. The National Crime Agency, the Crown Prosecution Service, the Department for Science, Innovation and Technology, the Youth Justice Board, NHS England, NHS Wales, the Department for Education, the Ministry of Justice, Ofsted, Counter-Terrorism Policing Headquarters, the National Police Chiefs Council, the Local Government Association, the Welsh Local Government Association, and the Association of Directors of Children's Services, all of whom have received Rule 9 requests spanning several of the topics. We have also sent Rule 9 requests to 4 leading teaching unions in relation to, in broad terms, the challenges of the management of violence-fixated individuals, VFIs, in education. On topic 2, the online environment, we have sent, or in some cases are about to send this week, Rule 9 requests to Ofcom, the UK Council for Internet Safety, and a range of internet and social media service providers and messaging platforms, X, Meta, Google, TikTok, Roblox, Discord, Snapchat, Telegram, and Reddit. We've also sent Rule 9s on the online environment aspects, importantly, to parent groups and other interest groups in this area, to the Molly Rose Foundation, the Centre for Countering Digital Hate, NSPCC, the Breck Foundation, the UK Safer Internet Centre, and the Internet Watch Foundation. We'll also be sending Rule 9 requests to both Moonshot and the Institute for Strategic Dialogue, both of whom are active in the area of terrorist and other new threats, including VFIs, and including in the sphere of the online environment. On Prevent, we have engaged with, and we will shortly be sending a Rule 9 request to the new Prevent Commissioner, Tim Jacks, and I shall mention others in this area in the context of the seminar evidence. Also on Prevent, we have sent a Rule 9 request to the Deterrence Centre, but also to 5 public interest groups with interest in Prevent, being the Child Rights International Network, Rights and Security International, Prevent Watch, the Resilience in Unity Project, and Amnesty International. We've also sent Rule 9 requests to His Majesty's Inspectorate of Constabulary Fire and Rescue Services because of their inspection of counter-terrorism safeguarding, which I'll come back to, and also to criminal law professional bodies in the legal sphere in relation to the effectiveness of current laws, orders, and sentencing. We have issued, or in a few cases are about to issue, a number of Rule 9 requests specific to topic 4, that's the effectiveness of current policies in relation to the sale and possession of offensive weapons and articles with a point or blade. These include the Trading Standards Association, the Advertising Standards Association, the Ben Kinsella Trust. There will be a request to Leanne Lucas in her role with Let's Be Blunt. A number of the mainstream large retailers of knives, both involved in online sales and in-store sales, to retailers in the outdoor market involved in the sale of knives, and to a very large range of the interest organisations and retailers involved in archery, concerning whether there should be controls on the sale of archery equipment other than crossbows, bearing in mind the archery equipment that AR had obtained and hidden. Finally, we've sent, or will this week be sending, Rule 9 requests to a number of clinicians and academics, Professor Busher at the Centre for Peace and Security at Coventry University, Dr. Richard Taylor, Clinical Lead for the Clinical Consultancy Service, Professor Samantha Lundegren, Director at the International Policing and Public Protection Research Institute, Dr. Gwen Adshead, Forensic Psychologist, and Dr. Nina Champaneri, the National Clinical Lead for Forensic CAMS. So that is a brief summary of the Rule 9 request activity. Early next week, we will provide call participants through an update with a complete list of the Rule 9 witness statement requests that have been made. It will, I hope, be apparent the efforts that have been made by the inquiry legal team to cast the net quite widely and also to seek a balance and a contrast of views, which is obviously important. As I've already indicated, constructive suggestions and input from call participants will be welcomed. The inquiry will not, of course, call all of those who provide witness statements to give oral evidence. It's intended that from these Rule 9 requests, those from whom you consider oral evidence will be most helpful to the exploration of our 4 topics will be called, in that topic order, topics 1, 2, 3, and 4, in the main Phase 2 evidence hearing blocks in October and November of this year. However, and importantly, statements from witnesses who are not called to give oral evidence do not have some kind of lower status. They generally will be published, and they will be an important part of your evidence base. So I'd said that I would come back to the timescales. We, as an inquiry team, are acutely conscious of the tight turnaround times for responses to the Rule 9 witness statement requests that are issued on your behalf. The issues in which we are engaged are urgent. The Home Secretary's timetable for our Phase 2 is equally as demanding as that for Phase 1, but for good reason. The inquest legal team is available to give practical assistance and guidance on responses where issues arise. But as with Phase 1, the inquiry is essentially dependent upon organisations giving what we fully appreciate is an almost unprecedented priority to their responses. And so can I indicate that we remain extremely grateful for the enormous collegiate efforts that are being made and which I know will continue to be made. Having summarised the more traditional witness statement evidence gathering, can I turn next, please, sir, to the alternative forms of evidence gathering, which are referenced indeed in your Phase 2 terms of reference. And the first of these is the questionnaires. The purpose of the questionnaires issued by the inquiry is to widen and deepen the evidence base on both the current approach adopted to VFIs, its strengths and weaknesses, and on the options for change. The Phase 1 report addresses, we hope and believe, in an appropriate forensic level of detail, the agency's involvement with AR. While that obviously overlapped with aspects of regional and national practice, the main focus in Phase 1 was on AR's individual case, and therefore on the agencies in Lancashire and Merseyside who were engaged with him. To look appropriately at what may need to change nationally, we're seeking to capture wider views through these questionnaires. Importantly, in a number of cases, the questionnaires are also designed to offset the risk that corporate witness statements are often rightly, and I don't say this critically, given by very senior officials or heads of organisations. And through the questionnaires, we're keen to understand more from those at a more working level. With those aims in mind, the inquiry has sent out, as you've indicated, sir, 8 sets of questionnaires. The first questionnaires have gone to channel chairs, that is to say the chairs of the panels whose cases are adopted by Prevent. Amongst many other topics, we're seeking from channel chairs information on the number of VFI-type cases dealt with by channel chairs, their views on the current multi-agency working for cases that are and are not adopted by channel, and for options for improvement and change in the future. The second set of questionnaires has gone to multi-agency public protection arrangement, that is to say MAPA chairs. Again, amongst many other topics, we're seeking information on the number of VFI cases currently being dealt with by MAPA, the MAPA chair's views on current multi-agency working, and the scope for MAPA playing a greater role in VFI risk management in the future. The third set of questionnaires has gone to Child and Adolescent Mental Health Services, CAMS. We're seeking to explore with them, amongst other topics, again, VFI prevalence, relevant clinical training, referral routes, how confident clinicians are in dealing with VFI cases, risk assessment tools, information sharing, multi-agency working, and how effectively forensic CAMS works with their CAMS services. Fourthly, we have sent questionnaires to forensic CAMS practitioners. So unsurprisingly, the issues there are broadly similar to those with CAMS, save for asking the flip side question of how effectively FCAMS considers CAMS services work with them. Fifthly and sixthly, we have sent questionnaires targeted respectively to local authority senior leaders, principally at Director of Children's Services level, and to a selection of frontline local authority practitioners. Topics addressed here include training, VFI prevalence, the effectiveness or otherwise of multi-agency working, whether they have sufficient access to specialist input and support, and the role and effectiveness of multi-agency safeguarding hubs, or MASH. Seventhly, we have sent questionnaires to a selective sample of designated safeguarding leads in education settings. Here again, we're seeking to explore the effectiveness or otherwise of multi-agency cooperation in VFI cases, training, teachers' confidence in handling VFI cases, risk assessments and information sharing, and their experience of Prevent, amongst other topics. Eighth and finally, questionnaires have now gone to detective inspectors for each of the regional counter-terrorism units in England and Wales. We're seeking for them to gather the views of relevant counter-terrorism policing Prevent practitioners in their teams. Again, topics include VFI prevalence, training, effectiveness of management of VFIs in Prevent in the current arrangements, multi-agency working, and the adequacy of tools to assess subjects' online activity. These questionnaires are hosted electronically. In the questionnaires and surrounding communications, emphasis has been given on the need for candour. It has been explained that the process is to gather insight, not to mark or assess the recipient's or recipient's unit's performance. For the most part, especially for more junior staff, they can respond anonymously. While these questions have not been designed to formal consultation and statistical standards, they have been drafted to allow a degree of meaningful data interpretation, with some questions having gradated scoring options. The inquiry intends, as you've indicated, to engage data analysts to consider the responses so as to provide the most meaningful output from these questionnaires. They will be looking for the thematic trends in responses, so this is generally different from seeking individual witness statements. So I turn next, with your permission, please, to seminars. So the Phase 2 seminars will be a programme of, we think, 6 days of seminars, which the inquiry legal team has organised under your direction. And I can indicate that this is planned for the first 2 weeks of the Phase 2 evidence in September of this year, and we hope to be able to confirm the precise dates quite shortly. The seminars will be delivered by a mixture of academics, commissioners, clinicians, relevant experts, interest groups, and in some cases by those currently operationally responsible for some areas of the response to violence-fixated individuals. The intention is that the seminars will be both evidence in their own right, but also important context for the more conventional evidence to follow. By giving speakers an opportunity to present in an extended seminar format, we hope that it will bring a different perspective to the traditional questioning format of conventional evidence. We will be finalising the precise format, which may vary a little bit from seminar to seminar over the coming weeks. But the current expectation is that each speaker will deliver their presentation individually, to be followed by a format of moderated questions in a plenary session at the end of each day of seminars. I can give some detail on what the seminars will contain. The first seminar will be entitled Violence-Fixated Individuals, Views from Psychiatry and Psychology. The speakers will be Professor Laura Smith, Professor of Psychology at the University of Bath, Dr. Tina Irani, forensic psychiatrist with experience of both forensic CAMS and community CAMS services, who of course was the inquiry's independent psychiatric expert in Phase 1, and a further forensic psychologist who will be confirmed, we hope, very shortly. The second seminar will be on the role of PREVENT in managing violence-fixated individuals. At present, our planned speakers are Lord David Anderson, KC, former Interim Commissioner of PREVENT, and the author of the report Lessons for PREVENT, following the Southport attack, to which I will return. Jonathan Hall, KC, the independent reviewer of terrorism legislation, and author of the report The Classification of Extreme Violence Used in the Southport attack on the 29th of July 2024, to which I will again return. Thirdly, subject to confirmation, Dr. Paul Betts, who's a former Detective Chief Superintendent of Police who was seconded to Counter-Terrorism Policing Headquarters. His final role there was serving as the National PREVENT Coordinator. But of help to us, Dr. Betts is now an academic with extensive, senior policing experience, including in PREVENT. Subject to confirmation, fourthly, Alistair Roxburgh, Legal Policy and Advocacy Advisor of Child Rights International Network, and fifthly, Sarah St. Vincent of Rights and Security International. The third seminar will be on violence-fixated individuals, lessons from threat management and multi-agency processes other than PREVENT. This seminar, sir, will be targeted at looking at risk management process other than PREVENT. It will also consider an example of risk management from overseas. The planned speakers are Becky Canning, His Majesty's Prison and Probation Service lead and joint head of the National MAPA team, Professor Bram Sizu, Professor in Clinical Psychology of Radicalisation at the University of Amsterdam, who will speak to the Dutch model, which is of particular interest. Thirdly, a senior representative from a violence reduction unit. Confirmation for that proposed speaker should come very shortly. And fourthly, Dr. Aslin Martin, consultant clinical psychologist in Trusting Hands, which is the NHS Vanguard site in Gateshead. The fourth seminar will be on violence-fixated individuals, the internet, online platforms, and pathways to violence. The planned speakers are Dr. Julia Ebner, leader of the Violence Extremism Lab, University of Oxford, Professor Paul Gill, Professor of Security and Crime Science at UCL, Dr. Joe Whittaker, Director of Cyber Threat, Swansea University, and Milo Comerford, Senior Director of Policy and Research at the Institute for Strategic Dialogue. The fifth seminar will be on violence-fixated individuals, access to and the attraction of offensive weapons and bladed articles. For this seminar, sir, the planned speakers are Commander Stephen Clayman, the National Knife Centre Crime Centre, Patrick Green, CEO of Ben Kinsella Trust, Professor Ian Brennan, Professor of Criminology at the University of Hull, and Tim Weston, Director of Environment Policy and Politics for the National Gamekeepers Organisation. And it's hoped that he will give an alternative insight, because the inquiry wishes and needs to hear from those who have a professional need for the use of knives, for example, in outdoor pursuits. So it's hoped that he will give that alternative perspective. The sixth seminar will be on violence-fixated individuals, the effectiveness of current laws and systems and orders. This will be in two parts. The first looking at legal powers and offline disruption. Planned speakers are the relevant specialist prosecutor from the CPS and equivalent speakers from the National Crime Agency and Youth Justice. The second part will be online frameworks, powers and disruption, with planned speakers there being Adam Hadley, the Director and CEO of Tech Against Terrorism, and Professor Lorna Woods, Professor of Internet Law and expert on online safety regulation. So may I just indicate publicly how very grateful we are for all of those speakers who have agreed to participate. Can I turn finally to the inquiry's case studies, which you have already briefly introduced? In selecting a number of case studies of other offenders for assessment, the inquiry is again seeking to broaden and deepen its evidence base. Albeit exceptionally rare and grave in its outcome, we are conscious that the Southport attack was one single dreadful event. We want to consider whether themes that can emerge from other recent VFI-like cases will help focus the conclusions and recommendations for this second phase of the inquiry's work. And so, as you've indicated, the inquiry has selected 6 case studies. We've already obtained proportionate disclosure in relation to these 6 cases. So, as you've already mentioned, but I ought to stress, the inquiry is not conducting a phase 1-like investigation into each of these individual cases. Rather, we are seeking to use them to identify the thematic lessons. The inquiry will not be looking to assess the rights and wrongs of actions by individuals or agency in these cases. The focus has to be on the themes that emerge and what can be taken from them. To assess the case studies, the inquiry has assembled a cadre of experts who will review the case papers and produce expert reports. At least one of those we think may be in the format of an individual report, but others may be in panel format. The experts have now agreed their commission from you for this task, and I can indicate publicly that they are as follows. Firstly, Neil Basu, former Senior National Counter-Terrorism Policing Lead, providing expertise obviously on policing, decision-making, escalation and disruption measures. Secondly, Dr. Richard Church, consultant forensic psychiatrist, specializing in high-risk children and young people with complex mental health needs. Thirdly, Dr. Monica Lloyd, forensic psychologist, specializing in terrorism and risk assessment, focusing on how risk violence fixation is identified and managed. Fourthly, Anna Gianfrancesco, former Director of Children's Services and Channel Chair, bringing extensive safeguarding and multi-agency expertise. And fifthly, Elizabeth Swan, former head teacher and safeguarding expert with extensive experience in identifying risk in education and indeed other frontline settings. So as you touched upon earlier this morning, we will be referring throughout the inquiry to the case studies by cipher. It bears some repetition that the reason for this is twofold. First, it is to emphasize that our focus is on the wider themes, not as such on the facts of these individual cases. But secondly, sir, as you've indicated, but if others will forgive me for re-emphasizing, we wish to avoid giving further notoriety to the offenders in question, which may increase the risk that these individuals present, but also the risk of copycat-style behavior. I will, however, name 4 of the 6 case studies once in this opening, as you've already indicated. In relation to 2 of the 6 case studies, you've made the anonymity orders to which you've referred. There are significant issues concerning risk, which means it is simply not appropriate to name them nor to give any details that may lead to jigsaw identification. The terms of the order are on the inquiry's website, and those restrictions must please be respected. Case study A is the first subject to the anonymity restrictions. Case study A relates to a convicted young offender who in a number of respects fits the category of a violence-fixated individual. Case study B is the second case study subject to the anonymity restrictions. Case study B also relates to a convicted young offender who in a number of respects fits the category of a violence-fixated individual. The subject of case study C was convicted of 3 murders and related firearms and bladed article offences. He planned for a firearms attack at his former primary school. The available material records fixation on mass shootings, viewing of extreme material, reconnaissance, forgery of a firearms certificate, purchase of a shotgun, and planning for suicide. He was sentenced to custody for life with a minimum of 48 years following a guilty plea. The subject of case study D murdered 2 women at random with a knife purchased from Amazon. He had previously been adopted into Channel after accessing far-right material on a school computer. He was sentenced to custody for life with a minimum of 2 concurrent 35-year periods. The subject of case study E carried out a series of violent assaults on elderly strangers in the same area, including attempting to drown 1 victim. He fatally stabbed a 12-year-old in a random knife attack. He was sentenced to detention for life with a minimum period of 13 years. And the subject of case study F used a licensed shotgun to shoot and kill his mother, then shot 6 people in the street, 4 fatally. He died by suicide at the scene. So as I've said, we'll be using the ciphers for these case studies throughout, but I can indicate that the subjects of case studies C, D, E, and F are Nicholas Prosper, Danielle Hussain, Kian Moulton, and Jake Davison, respectively. The inquiry asks that core participants in the media refer to them by their ciphers whenever used within the context of the inquiry, for the reasons that you have already made plain. So we plan to hear from the Cardiff experts about these case studies, and that evidence will probably be at the start of October. So can I turn now, and thirdly, to an introduction to each of the topics in the Phase 2 terms of reference. Could we have on the screen, please, ILT 30111? So the inquiry has published a document entitled Approach to the Phase 2 Terms of Reference. This is publicly available already on our website, and is the starting point for understanding the sub-issues we intend to address under each of the topics in our terms of reference. I'm not going to read every line of this, although I will come back to it in places during this opening, but for the moment that can come off the screen. Thank you. The first of the 4 topics, it's important that I should first of all publicly read out the terms of reference. So topic 1 is the adequacy of arrangements in England and Wales for managing the risk from violence-fixated individuals, VFIs. VFIs are individuals at risk of extreme violence where ideology is not the primary driver. Where arrangements are considered inadequate, the inquiry is asked to make recommendations for improvements. In particular, the inquiry should examine A, how effective are multi-agency arrangements for identifying, assessing, and managing the risk posed by VFIs. This includes prevent, youth offending teams, and policing. B, how integrated are these arrangements with wider safeguarding systems, mental health services, social care, and education? Could improvements be made to better identify and manage VFIs? C, what interventions reduce the risk to the public from VFIs? What barriers exist to delivering them? And how can they be overcome? And D, do other threat management systems, such as those for terrorism or organised crime, have lessons for good management of VFIs? So one only needs to reflect on that first topic in our terms of reference for a moment to recognise both the complexity and the importance of the issues involved. Topic 1 also highlights two important characteristics of this inquiry's Phase 2 work. The first is that the inquiry is by no means the only body that has been and is active in considering this challenging area. And as I shall outline, a number of other bodies have been working in this area and have issued helpful, relevant reports. Secondly, and importantly, this is not a policy area that the UK government has tasked you to consider while pausing its own consideration. Quite the opposite. As would be expected, the government has, we know, been actively contemplating the best approach to this difficult area since the Southport attack itself. Some actions have already been taken, but many other policy options are still, as we understand it, being formulated and considered. And to give proper context to this first topic, I need to expand, I'm afraid, in some detail on both of those aspects. So can I start with the other bodies who've carried out or are still carrying out relevant reviews? And there are 6 reports here, sir, that with your permission I'd like to introduce. The first is Lord Anderson's report on lessons for prevent. So as is very familiar to you, on the 21st of January last year, when the Home Secretary announced that this inquiry would be established, she also announced that Lord David Anderson KC would be appointed the interim Prevent Commissioner, and that Lord Anderson's first task would be to conduct a thorough review of the Prevent history of AR to identify what changes were needed to make sure serious cases are not missed, particularly where there is mixed and unclear ideology. So if we can have on the screen, please, ILT 30106. This is Lord Anderson's report, Lessons for Prevent. It's dated July of 2025. And if we can go forward to page 3, please, we can see from the top paragraph that in the event Lord Anderson's report was also tasked with covering the killing of Sir David Amess in 2021, as well, of course, as the murders and attempted murders committed by AR in the Southport attack. So I don't want to overlook Chapter 3 of Lord Anderson's report, which considered AR's referrals to Prevent. But if we could look briefly, please, at page 6 and paragraph 8, please, Sarah, we see that Lord Anderson himself noted that his assessment of the Prevent referrals of AR should be seen as a bridge between the early Prevent learning review that had already taken place and your own findings to be made in this inquiry, sir. And of course, since then, your Phase 1 report has considered AR's Prevent referrals in considerable detail, so I don't need to go into that for the purposes of this Phase 2 opening. But for Phase 2, the significance of Lord Anderson's report lies more, for your notes, in his Chapter 4, which sets out recent Prevent developments, Chapter 5, with his views on the future shape of Prevent, Chapter 6, in which he addresses a number of further issues, and his conclusions in Chapter 7 and recommendations in Chapter 8. Taking those as briefly as I can, sir, for today, I wish to start just by emphasising in particular the analysis of Lord Anderson in Chapter 5. So if we could look, please, next at paragraph 5.3 on page 99. We see that Lord Anderson considered 2 critical questions. A, should Prevent accommodate violence-fascinated individuals who lack a clear identifiable ideology? And B, would Prevent be better as part of a general violence reduction strategy? And Lord Anderson said that the first of those questions requires an urgent answer. The second is an issue for the medium to long term. So Lord Anderson answered the first of those questions, yes. That is to say that VFI cases should continue to be accommodated within Prevent, even though they lack clear identifiable terrorist ideology. Lord Anderson's reasoning is set out in detail in his report, but in the shorter summary, in coming to that conclusion, Lord Anderson drew attention to the seriousness and increasing trend of the nature of the VFI-type threat. He noted the pressure that counterterrorism policing are under because of the increase in referrals. And he acknowledged that one suggested solution had been that the lead management of VFIs would sit below and distinct from Prevent in a new standalone system. So that's for your note, paragraph 5.16, but we don't need to turn it up. But ultimately, Lord Anderson's conclusion on this aspect was expressed in paragraph 5.23. Can we have that on the screen, please? It's page 106. Since this is at the heart of matters, I will read it. So we don't probably need the footnotes, just the top, please. The arguments in favour of what is effectively the status quo and the current interim policy position, under which persons displaying fascination with extreme violence or mass casualty attacks are considered legitimate subjects for Channel, are, in my view, strong ones. In particular, A, the modus operandi of such attacks and characteristics of the attackers bear strong similarities to those which are familiar from lone operator terrorist attacks. B, attacks by such people have the potential not only to kill vulnerable victims, but to create fear and unrest on a scale comparable to that generated by terrorism. C, AR's story demonstrates that Channel can reach such people. Indeed, had it been clearer that this was its proper function, it would have been more likely to have done so. And D, above all, ideologies, fascinations, and ideations are in the mind. It can be hard to tell one from the other, and not only in the immediate aftermath of a Prevent referral. Experience shows that whether an individual has a single fixed ideology, a simple violence fascination, or something in between may remain obscure, even in the case of a completed attack, up to the point of trial or beyond. And so if we can look at page 108, Lord Anderson, it's the top third of the page, please, Sarah. In his second recommendation, which flowed from this conclusion, Lord Anderson said, recommendation 2, Prevent should remain open to individuals falling within the existing category of fascination with extreme violence or mass casualty attacks. Consistent efforts should be made to improve the quality of referrals and encourage those that are appropriate, including by providing clear and consistent messaging to potential referrers and to Prevent practitioners. So that was the first of those key questions. On the second issue, the medium to long-term question of whether Prevent would be better as part of a general violence reduction strategy, Lord Anderson also suggested that the answer was yes. To understand that a little bit more, can we look, please, on the same page, at 530 and 531. And again, because of its centrality, I will read these passages. So he said, I turn now to a proposal less urgent but more ambitious than the one just discussed to place Prevent within a comprehensive safeguarding and violence prevention strategy behind what is sometimes referred to as a big or wide or agnostic front door. And he expressed that he was indebted to his deputy, Suzanne Jacob, OBE, with her wide experience of safeguarding and multi-agency working, for developing this idea and testing it with many of those to whom we spoke during the review. And then he went on to the essence of the proposal and said this. In an article published earlier this year, it was argued that, quote, integration of local authority safeguarding boards with channel boards would ensure that all safeguarding cases are dealt with by a unified body capable of determining the best intervention for a young person. By incorporating channel into the broader safeguarding system, cases can be triaged to the most appropriate support, i.e. mental health services, social care, or counter-terrorism radicalisation interventions. In many local authorities, channel will already be involved with other safeguarding responsibilities. This makes it a natural fit, which also guarantees wider safeguarding duties can be effectively cross-pollinated with Prevent's counter-terrorism expertise. And you can see there, just before we leave that, sir, that footnote 283, upon which Lord Anderson were relying, was an article from the Institute for Strategic Dialogue, from whom we will hear in our seminars. So I'm not obviously going to go through them all, but Lord Anderson's report sets out the potential advantages of such an approach. Can we just look briefly at the foot of page 109, please? And over the page to 110. So they're listed there, and I'm not going to read them all out. At the foot of page 110, so at the bottom of page 110, please. Thank you. He also notes the existing models, areas where the government is already showing what's described as an ambition to move to a more integrated system of safeguarding. It's the bottom of page 110. And then at page 112, please, paragraph 5.40. Here, sir, Lord Anderson listed a number of challenges in the way of the big front door approach. And you will see, sir, that he said at the top of page 540 that they are many. It's notable that within these challenges, Lord Anderson principally envisaged that multi-agency safeguarding hubs, MASH, in perhaps expanded form with amended statutory thresholds, would be the body taking forward referrals at the triage stage of the big front door. So in due course, you may need to reflect further on the failures of the MASH in AR's case adequately to address signs of his increased risk. And perhaps consistently with that, if we could go over, please, to the top of page 113, significantly, it might be thought, Lord Anderson said this at 540 subparagraph D. The most developed MASHs and equivalent bodies are highly functional. They deal with all age categories, have a robust case-working system, and enjoy both interoperability and good working relationships between the agencies. However, in some areas, these features are not present. The ground to make up in areas with less developed MASHs, both structurally and culturally, will seem daunting. However, on a more optimistic note, slightly further down the page, he went on to say that while these and accompanying challenges are substantial, they are not insurmountable, and that creates the right kind of multidisciplinary team overseen by a minister and staffed by officials able to be open-minded, pragmatic and practical, should be able to break this issue down into component parts and find both quick wins and longer-term improvements. So following and flowing from this, Lord Anderson's third recommendation, can we just look at the top of page 115, please, 115. Recommendation 3, a Cabinet Office task force should be established to lead exploratory work into the possibility of formally connecting Prevent to a broader safeguarding and violence prevention system. Thank you. So last week, the government responded to Lord Anderson's report as well as to your Phase 1 report. Our reference for that, although we don't need to turn it up, is ILT 30112. Summarising it as shortly as I may, in response to Lord Anderson's recommendation 2, that is that VFI cases should continue to be dealt with by Prevent, the government set out a number of the improvements to Prevent. It being implicit, as we understand it, the VFI cases will indeed, in appropriate cases, continue to be dealt with, at least for the time being, by Prevent. In response to recommendation 3, the Home Secretary referred in her response last week to the fact that she has set up the cross-government task force in the Home Office, which will draw on Cabinet Office expertise, and that no doubt was a reference because the recommendation was that it should be a Cabinet Office task force. But it's now a Home Office task force which will draw on Cabinet Office expertise and which will support and which will work alongside phase 2 of this inquiry. So I regret that I am bound not to have done justice to Lord Anderson's report. Its full content bears detailed and repeated consideration. And of course, it is with this report in mind that Lord Anderson has been chosen by you, sir, as an obvious key speaker in our September seminars. Can I turn for the second report to the independent review on classification of extreme violence used in the Southport attack on the 29th of July 2024? This second report, sir, was also conducted, as you know, as a direct result of the Southport attack. And it was completed by Jonathan Hall, who is, of course, the independent reviewer of terrorism legislation. Like Lord Anderson's report, Jonathan Hall's report was commissioned by the Home Secretary and announced in the same 21st of January 2025 statement. The purpose of Jonathan Hall KC's report is clear from the Home Secretary's announcement when she said, "We need to ensure our laws keep up with the changing violent and extremist threats that we face. It is for the police and CPS to decide whether individual cases meet the definitions set out in the Terrorism Act 2000 when making charges. But given the growing number of cases where perpetrators are seeking to terrorize, even without a clear ideology, we need to ensure that the law, powers and sentencing are strong enough to cope. I have therefore asked the independent reviewer on terrorism powers to examine the legislation in this area in light of the modern threats we face," end quote. So if we can have on screen, please, ILT 30100. This is Jonathan Hall's report of the 13th of March last year, and helpfully the 3 key conclusions from his report are set out in a very pithy executive summary. So he concluded, firstly, that the legal definition of terrorism is already wide and should not be changed any further. Secondly, he concluded that lessons from counter-terrorism are, however, relevant to managing the risk from individuals who plan to carry out extreme violence for its own sake or because of personal grievance. And thirdly, he concluded that the government should consider a new offence adapted from terrorism legislation to deal with non-terrorist mass casualty attack planning. So taking that last point first, in the initial response to your Phase 1 report in Parliament, the current Home Secretary said on the 13th of April this year that legislation for this will be brought forward as soon as parliamentary time allowed. And it was indeed part of the King's speech in May this year that the government will, quote, respond to the horrific attack in Southport with measures to protect the British people from extreme violence and honour the victims, the injured and their families, end quote. Jonathan Hall's report also addressed the need for an offence of having a weapon in possession, even in private, with an intention to carry out an attack. And that part of his recommendations the government has sought to address already by the new offence, which is included in Section 28 of the Crime and Policing Act 2026, of possessing an article with blade or point or offensive weapon with intent to use unlawful violence. And so on indictment, that offence is now punishable by 7 years imprisonment, increased from 4 as intended at earlier stages of the bill's progression through Parliament. In terms of Jonathan Hall recommending that no change to the definition of terrorism was required, notwithstanding how extreme and horrific the Southport attack was, Jonathan Hall was careful to seek to correct certain misconceptions. And if we can look, please, at page 3 of his report, he made clear, first of all, at paragraph 1.9, as so, of course, is very familiar to you, that all murders, whether terrorist or not, are prosecuted as murder. There is no separate offence of terrorist murder, only murder. And then additionally, at paragraph 1.10, he stressed that terrorism is not a label for the most serious offending and shouldn't be understood in that way. And thirdly, at paragraph 111, just a bit further down the page, please, he emphasised that the true purpose of the terrorism definition is to unlock special powers of early intervention based on years of counter-terrorist experience, initially in Northern Ireland, later throughout the UK, and to secure international assistance from allies and third countries because of a shared interest in countering specifically terrorism. Can we look, please, in that context at paragraph 2.1 on page 8, please? This is useful because it contains a pithy, helpful, and practical short-form explanation of the full legal definition of terrorism. So, limb 1, there must be a use or threat of action that hits a certain threshold of seriousness. An action must involve serious violence against a person, serious damage to property, endangerment to another person's life, a serious risk to the health and safety of the public, or be designed seriously to interfere with or disrupt an electronic system. Limb 2, the use or threat must occur on a wider scale than the personal. It must be designed to influence the government or an international organisation or to intimidate the public or a section of the public. There is, however, no limit to the section of the public, and an unanswered question over whether any intimidated group of victims is sufficient to qualify. And then limb 3, the use or threat must pursue a specified objective being made for the purpose of advancing a political, religious, racial, or ideological cause. So as Jonathan Hall identified, for AR, and the same would apply in most other VFI cases, it is the absence of the third limb that prevents the offending from amounting to specific offences under the terrorism legislation. Mr. Hall's report contains at Annex 2 10 other lone actor cases which involve the use or threats of extreme violence but were not prosecuted as terrorism. And that serves perhaps to emphasise the gravity of the threat. And we're taking up 2 of those examples in this inquiry's case studies, case study D and F. But if we turn, please, to page 19, section 4, paragraph 4.1, Jonathan Hall there sets out key reasoning against amending the definition of terrorism. So he said, the definition of terrorism can be compared to a tugboat pulling a container ship that gets heavier every year. The container ship holds all of the offences, investigative powers, counter-terrorism measures, policies and operational arrangements that depend on the definition of terrorism and which are expanded year on year. And then a little further down at 4.3, he said, such is the functional importance of the terrorism definition that redefinition would alter the landscape. It would risk major false positives, the prosecution of people who by no stretch of the imagination are terrorists, and extend terrorism liability into novel terrain. For example, any person who glorified extreme violence would be at risk of arrest and prosecution as a terrorist. People swapping violent war footage would be at risk of encouraging terrorism, resulting in unacceptable restrictions on freedom of expression. So I won't go through, because of constraints of time, the remainder of section 4, save to note that it contains detailed and careful reasons against expanding the definition of terrorism to encompass those who are fixated with extreme violence, but without the intention of pursuing a political, religious, racial, or ideological cause. So importantly for our work, on the 13th of March 2025, the then Minister of State for Security, Dan Jarvis, announced that the government accepted Jonathan Hall's conclusion that no change to the definition of terrorism should be made. Beyond this, Jonathan Hall's Chapter 5 on counterterrorism lessons is of direct relevance to our Phase 2 work. Can we have on the screen, please, page 24? Thank you. And it's paragraph 5.8. So starting there, the counterterrorism system has developed over time and through deep experience of terrorism in its various manifestations, a consistent national model for identifying and triaging or categorizing national security threats with a standard approach to record keeping and accountability and methodology for how the resulting risk is managed. The level of intervention, and he names a particular case, AA's case, is neither possible nor suitable for every subject of interest. A key issue is prioritization. And then reading on into the section, a new cohort, he says this: having discussed these matters in some detail with counterterrorism police and MI5, I accept that it is this standardized model for identifying and managing risk that is most relevant to managing violence obsessives. It is relevant that if, as I believe to be the case and is increasingly recognized, a new internet-related threat cohort is emerging, obsessed with violence, some of them qualifying as terrorists, but some of them, like AR, not. I suggest that the following two questions need to be answered. Firstly, is it possible to identify coherent national standards for identifying and managing the riskiest individuals within the cohort? Counterterrorism police and MI5 are informed by the latest research on the factors that draw young people into violent extremism and have built up experience of monitoring dangerous lone actors. They've been contemplating for some time the fiendish puzzle of how, and then over the page please, to distinguish internet rhetoric and real-world attack planning. If progress is being made, even if it's only in the identification of false assumptions, can this be communicated more widely to law enforcement? And then he said, secondly, it appears likely that individuals such as AR will continue to be identified within the counterterrorism system, for example, through referral to PREVENT. But if they are not to be managed by counterterrorism police, who will own the risk? What handoffs will exist from and to counterterrorism police? Intuitively, if there is a new risk cohort, then as with serious and organised crime or sex offenders, a bespoke policing response is needed. But I recognise that intuition is not a sensible guide to recommending organisational change, and that an evidence-based approach informed by the questions above is needed. And he then went on to address multi-agency systems. And he said it's been widely accepted since 2017 that even in terrorism cases, investigators should consider the potential benefits of involving local authorities, GPs, mental health practitioners, charities, housing associations, education providers, and families who may have first-hand knowledge of escalating danger. The point is to increase the number of protective factors, such as stable housing or regular employment. All sorts of formal and informal arrangements exist within policing to coordinate information sharing and joint efforts, such as multi-agency public protection arrangements, MAPA, for released offenders, and multi-agency support hubs for children and young adults. The clinical consultancy service is a collaboration between counterterrorism police and mental health clinicians to manage and understand mental health risks within counterterrorism police's casework. The Fixated Threat Assessment Centre, FTAC, is a collaboration between police and practitioners for individuals dangerously fixated on celebrities. And I'll come back to that, sir. And Mr. Hall continued, if it is to be suggested that existing multi-agency systems are already sufficient to deal with this cohort or can be easily tweaked, I would make three observations based largely on my early reviews of MAPA and terrorism in prison. Firstly, the existence of multi-agency arrangements should not obscure the need for the most qualified professionals to take, and over the page, responsibility for public protection. This is generally the police who understand the assertive risk management options such as arrest or civil order if the risk spikes. Secondly, information sharing must be robust and not tangled in hard-to-use data protection considerations. Thirdly, there is a danger of aspirational but unrealistic talk about the availability and utility of support available from charities and the wider public sector. If child and adult mental health services, CAMS, or adult social care is to be discussed as a possible intervention, what is the waiting list? If a local authority's adult social care services are available beyond cases of severest need, how many hours in a week will a lonely and isolated but still functioning individual receive? How does therapy compete, if at all, with hours on an absorbing and violently transgressive internet platform? So I make no apology for reading out significant passages of that report, because Jonathan Hall is there speaking with all his experience to the very heart of issues with which we need to grapple in phase 2. And Jonathan Hall underlines in these passages from chapter 5 the benefit of lessons from terrorism cases managed under Prevent and Channel and process for addressing terrorism cases those lessons being applied to VFIs. But one also sees in Jonathan Hall's report a clear warning against underestimating what would be involved in adapting existing multi-agency arrangements to accommodating the management of VFIs. So a third in terms of significant reports directly relevant to phase 2 and topic 1 in particular is the report of the Home Affairs Committee Combating New Forms of Extremism, which was published on 1st of April of this year. Could we have on the screen, please, ILT, it's 4099, which is the front page of the Select Committee's report. So just to divert for a moment, since this is a parliamentary report, I ought just to mention the position concerning parliamentary privilege. Article 9 of the Bill of Rights of 1689 provides in modern language that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. It's not necessary for today's purposes to get into some of the complexities to which this gives rise, nor to the different approaches that have been taken by different public inquiries. But in referring to the Home Office Affairs Committee's report, which is covered by parliamentary privilege, it's important to emphasise that the inquiry is not seeking in any way to impeach or to question the proceedings before Parliament. Far from it, we're using the report to note the opinions that are expressed, and we are using it as a source of helpful evidence provided to the committee, which helps informs the issues that you, sir, are required to examine. We would simply ask all core participants during phase 2, however, to be mindful of the position on parliamentary privilege. In particular, that it is not permitted to deny, dispute or question the worth, truth, genuineness or accuracy of the content of parliamentary material, and that includes evidence given to a parliamentary committee. In cases of doubt, core participants should liaise with the solicitor of the inquiry. But in reality, sir, parliamentary privilege, while important, should not in practice be a bar to our phase 2 work, bearing in mind why we're going to be referring to this report and evidence given to it. But it is simply as well to be aware of the restrictions. So turning now back to the substance of the report, if we can turn to page 8, please. The particular relevance of this report is apparent from the introduction here in paragraphs 2 and 3. So paragraph 2, in April 2025, we published our report on the police response to the 2024 summer disorder, which followed the murder of 3 children in Southport. While that report focused on the policing of disorder following the tragic events in Southport, we were also concerned that the perpetrator of the attack had been referred to Prevent 3 times, with each case closed on the basis that he did not meet the threshold for a terrorism risk. The final referral related to concerns about his online activity. We explored this issue further in private meetings with the National Crime Agency and decided to examine emerging trends in extremism, the role of online spaces, and what happens to individuals whose cases fall below the threshold for being at risk of radicalisation to terrorism. The title of this inquiry is Combating New Forms of Extremism. Our primary focus has been on the growing number of children and young adults, mostly male, who are being radicalised online. When we talk about new forms of extremism, we refer to the combination of the young ages of those involved, the diversity and fluidity of their belief systems that incorporate different ideologies and do not fit into traditional categorizations, and the central role of online platforms in exposing and drawing them towards harmful content. We also note the high proportion of individuals who are neurodiverse, particularly those on the autism spectrum, being drawn into new forms of extremism. As regards a key issue for this inquiry in phase 2, namely the structures for managing BFI cases, can we look please at page 59, which is part of this committee's overall conclusions. Can I start at paragraph 8, please? The escalation in prevent referrals involving no clear ideology and no clear signs of radicalisation to terrorism represents a significant challenge to a system designed to address the ideological roots of terrorism. Prevent and Channel are becoming saturated with such individuals, many of whom show no commitment to any particular ideology, and some of whom are neurodiverse. The Home Office is allowing the Prevent system to drift beyond its remit without providing any strategic direction to meet these challenges. Conclusion, paragraph 88. And then Prevent is poorly adapted to deal with the digital world. We've outlined how online spaces are now central to the radicalisation process, particularly for young people. Yet Prevent lacks the specialist knowledge or framework for identifying and assessing credible risk signals from online behaviour. Integration of Prevent into wider safeguarding systems is being hampered by poorly resourced, overstretched and siloed agencies working against misaligned priorities. Against this backdrop, Prevent has become a fast track to support, even when concerns are not terrorism related, and particularly in relation to accessing mental health support. Conclusion, paragraph 89. And then in paragraph 10, we recommend that the Home Office makes a clear, specific statement to clarify the role of Prevent in addressing non-ideological cases and makes any necessary updates to relevant Prevent guidance and training to reflect that position. The government should also set out a plan to anchor Prevent more firmly within the wider safeguarding system. To deliver this, the Home Office should look to implement Lord Anderson of Ipswich's recommendation to connect Prevent to a broader safeguarding and violence reduction system. This will require strengthening the capacity of local safeguarding systems and significantly raising the level of training and competence among Prevent duty practitioners. See recommendation paragraph 90. So, sir, you will see that that is clear support from the Home Affairs Committee for Lord Anderson's suggested approach for Prevent being connected to a broader safeguarding violence reduction system. And just to make the link and to understand that reference to recommendation at paragraph 90, can we just please turn up page 51 from the same document? So may I ask you just to note for your record paragraphs 88 and 89, but I won't read them out because it reflects what I've already read. But at paragraph 90, please, recommendation, we recommend that the Home Office makes a clear, specific statement to clarify the role of Prevent in addressing non-ideological cases and makes any necessary updates to relevant Prevent guidance and training to reflect that position. The government should also set out a plan to anchor Prevent more firmly within the wider safeguarding system. To deliver this, the Home Office should look to implement Lord Anderson of Ipswich's recommendation to connect PREVENT to a broader safeguarding and violence reduction system. This will require strengthening the capacity of local safeguarding systems and significantly raising the level of training and competence among PREVENT duty practitioners. So before I turn to the government's response to this report, can I please just place some emphasis on the significance of the evidence that was provided to this parliamentary committee? As the inquiry legal team has been preparing requests for statements from relevant departments and organisations, as well as arranging the seminar programme, the evidence provided to the Home Affairs Committee has proved extremely useful. If we can just look briefly at page 62, please, you'll see, we don't need to go through it, but you'll see that there is the conventional list of those who gave live evidence, and of course their live evidence is publicly available. Some of those involved in giving live evidence will also be involved in the inquiry's seminar or in the provision of Rule 9 statements and oral evidence. But also, if we can turn to page 59, thank you, please, you'll see that there is sorry, it is 64. You'll see that there's a list of published evidence received by the committee. And so inevitably, with a long list like this, it goes on for quite some pages, and I risk doing a disservice to those I omit. But amongst that written evidence are contributions from the Centre for Peace and Security, Child Rights International Network, the Institute for Strategic Dialogue, the Local Government Association, Rights and Security International, Tech Against Terrorism, the Association of Directors of Children's Services, and the Youth Justice Board. That really is not meant to exclude the relevance of others that I haven't listed, but these are amongst the organisations from whom the inquiry is seeking further evidence. So I flag that up because on any view, the publicly available written evidence and oral evidence provided to the Home Affairs Committee is a very rich vein of relevant and helpful views, sometimes starkly contrasting views. Within that body of evidence are what may broadly be termed public interest or rights groups who are critical of the PREVENT programme. As I've indicated under the seminars and information on the inquiry's Rule 9 request, the inquiry is seeking the input from that body of organisations. We do note that the PREVENT programme, its strengths and weaknesses, is not of itself part of the Phase 2 terms of reference. This is not an inquiry into PREVENT. And so some of the broader critiques of PREVENT are beyond the inquiry's remit. However, the question of whether PREVENT is the best vehicle for tackling VFI cases is a central aspect of Phase 2 of this inquiry. And so we will want to consider the views of these groups on subjects such as their concerns about the neurodivergent as a cohort within PREVENT referrals, the effectiveness of PREVENT in VFI cases, and also concerns around equality of treatment insofar as they are relevant to VFI cases. So the government responded to the Home Affairs Committee, and its response was published just under 4 weeks ago on the 11th of June. If we could have on screen, please, ILT 30105. This is the government's response. And in dealing with the inquiry's topic 1, I want to focus on the response to the recommendation I highlighted a moment ago. So if we can turn to page 14, please. I won't read it out, recommendation 4, because you'll recognise it, sir, from that which I've just read. But the government's response to that recommendation, including in relation to Lord Anderson's recommendation, was that in February, the Home Office published clear guidance on PREVENT thresholds entitled Key Principles of PREVENT to help ensure there's a shared understanding of the purpose of PREVENT and the circumstances in which it should be used. These messages were reinforced and replicated in the PREVENT duty training packages. This guidance clearly sets out that while ideology is an important consideration, it is not mandatory for a PREVENT referral. PREVENT is an early intervention programme that must consider when someone is at risk of being radicalised to terrorism, rather than limiting PREVENT to cases where a terrorist ideology has already taken hold. Prevent is a counter-terrorism capability, so where there is not a concern that someone may be drawn into terrorism, alternative local support services should be considered. The government is considering the findings from phase 1 of your inquiry, sir, alongside the recommendation made in Lord Anderson's Lessons for Prevent report. As Sir Adrian Fulford concluded, Prevent and Channel are not the answer for all such cases. However, the government has made improvements since the Southport attack to strengthen the Prevent programme. To strengthen Prevent, we've launched a new Prevent risk assessment tool, changed the approach to repeat referrals so that cumulative risk is considered, introduced new guidance and training on a range of ideologies and threats, and have expanded the range of interventions available to people being supported by Channel. We've also introduced the role of Independent Prevent Commissioner. And over the page, I think, the government has also strengthened the approach to knife crime, introduced stricter laws in crime and policing bill for online sellers of knives, including strengthening age verification controls and checks at sale and delivery. We are also ensuring every child caught carrying a knife will now be given a mandatory targeted plan to tackle the root causes of their offending. To address harms online, the Online Safety Act is a significant step forward and one of the most robust systems globally. Platforms now have duties to identify and remove illegal content and to protect children from harmful content, with Ofcom robustly enforcing these duties. Whilst government has already begun to make improvements to help keep the public safe, there is much more to do. The government will bring forward legislation to help tackle violence-fixated individuals in this parliamentary session. Proposed measures are a new offence for preparing a mass casualty attack, and I pause to mention that that obviously reflects Jonathan Hall's recommendation, and measures to prevent the spread of extreme violence content online, and I'll come back to that. On 20th of April, the government announced its commitment to set up a Home Office-led task force to develop a new approach to tackling the risk from such individuals. The task force will develop an approach to tackling the risk posed by violence-fixated individuals and will run alongside phase 2 of the Southport inquiry. So there's then more detail on Prevent training, which, if you'll forgive me, I will note, but not read out. So the government's response in relation to that recommendation has been to emphasise the Home Office-led task force, to which I shall return, and this inquiry's phase 2 work, which will be working in parallel. Significantly, however, the government has not, to our understanding, committed or made up its mind, one way or the other, to the suggested longer-term solution of connecting Prevent to a broader safeguarding and violence prevention system, or in short, the big front door concept. So can I turn to the fourth report, which is the significant work being undertaken by His Majesty's Inspectorate of Constabulary and Fire and Rescue Services. So as to this, in October 2025, the Home Secretary commissioned the Chief Inspector of Constabulary under Section 54(2)(b) of the Police Act 1996 to inspect how police forces, counter-terrorism policing and partner organisations safeguard young and vulnerable people. Could we have on the screen, please, ILT 30102? If we could have the top half expanded, please, Sarah. Thank you very much. And you will see that the terms of reference for that inspection are as follows. We will examine the safeguarding measures they adopt for young people under the age of 25 and other vulnerable people who may be at most risk of radicalisation or exploitation by extremist groups or are under investigation for terrorism offences. In our inspection, we will address the following questions. How effectively do police forces and CTP understand the nature and scale of existing and emerging risks? How effectively do police forces and CTP share relevant intelligence between themselves and partner organisations to make sure risk assessments and safeguarding referrals are based on all available information? How effectively do police forces and CTP safeguard young and vulnerable people, including how they use measures described in the Prevent strand of the UK's Strategy for Countering Terrorism 2023, that's contest? How effectively do police forces and CTP manage the risks associated with young and vulnerable people, including how they use offender management, safeguarding and other measures described in the pursue strand of the contest strategy? Thank you. That can come down from the screen. So while there is an emphasis there on what we might term more traditional terrorism, given the obvious relevance of significant parts to those terms of reference to our phase 2, as you would expect, sir, your inquiry legal team have been liaising with the inspectorate. We understand that the inspection report is not yet completed, but we also understand that they may be able to publish a summary of their report in the autumn. Given that work on the report is still in train, there is little more that we can say at this stage, save that it is plainly a very considerable piece of work in its own right, which will undoubtedly and helpfully add to the evidence base for phase 2 of this inquiry. One of the particular benefits of this inspection report is likely to be its access to individual counterterrorism policing regions and case files, looking at the ground level operations in a way that inspectorate is particularly well equipped to carry out. So before we break for lunch, can I turn to the 5th of the reports, which you mentioned in your statement this morning, which is the report of the Independent Commission on UK Counter-Terrorism Law, Policy and Practice. So, sir, so far in looking at other reports, I focused on reports commissioned by the government from inspectors and commissioners and at the Home Affairs Committee report. I turn in this report to look at what is an independent report, the report of the Independent Commission on UK Counter-Terrorism Law, Policy and Practice. The Commission is an independent one comprising 15 commissioners, chaired, as you know, by the former Lord Chief Justice for Northern Ireland, the Right Honourable Sir Declan Morgan, and their report was published in November 2025. Can we have it on the screen, please? It's ILT 30103. And if we go to page 4, just highlight perhaps the top half of the page. First of all, can we just scroll down just a little bit so we see a longer part of the list? So I don't intend to read out the totality of the list, but I put this on screen just so that the seniority and breadth of the commissioners is obvious. And can we just have the second half of the screen, please? And then over the page, just to the top of page 5. So beyond Sir Declan, I won't read those out, but the experience and seniority is plain to see. So this is a substantial report, over 300 pages long, to which, again, I am absolutely sure I will not do justice in an opening such as this. We should also note that the breadth of this report means that it tackles a number of issues that clearly fall outside this inquiry's terms of reference. But for the purposes of this opening, I just want to flag a number of the key findings that are more on point and some of the observations and recommendations in this report. So can we go first, please, to page 108? This is, as you see on screen, sir, section 6 on reforming PREVENT towards a multi-agency safeguarding model. And if we just scroll down a little bit, again, with apologies for reading out the text, but it's important. It says, this chapter sets out the argument for public service reform to ensure PREVENT is fit for purpose in meeting a complex and ever-changing threat environment. While PREVENT should be kept as an element of a wider safeguarding infrastructure, reform is necessary at central and local government levels. These proposals build on evidence to the Commission on multi-agency approaches already working effectively in many local authorities in adjacent policy areas, such as violence reduction, public health and children's services. A first version of these arguments was given to the Security Minister in September 24. In December 24, a working paper was shared with relevant government officials and Lord Anderson KC following his appointment as independent PREVENT Commissioner. Key findings of Lord Anderson's report, Lessons for PREVENT, which addresses developing an effective response to significant changes in the cases referred to PREVENT, largely aligns with that earlier paper. they're part of the evidence suggesting broad support for our proposed reforms. So you see there a broad agreement between this Commission's views and Lord Anderson's report. And if we go over the page, please, to 109, you'll see that developed further. And you'll see that what's said there is our findings concur with Lord Anderson KC that until the development of a wider system to deal with such violence fascinated individuals, they should be considered through PREVENT. However, this risks both diverting attention from ideological related terrorist risk, for which PREVENT was originally designed, and failing to identify appropriate support for the root issues these people face. In this chapter, we outline the case for longer-term reform. So just pausing there, so that's an agreement with Lord Anderson's first question, that in the short term, PREVENT should continue to deal with such cases, but a warning that it's not an appropriate, in their view, long-term solution. And then at section 6.3, please, on page 116, we see it said that our inquiry, the work of Lord Anderson, and most recently proposals put forward by the Institute for Strategic Dialogue, all suggest the need to create a big front door to which all those susceptible of being drawn into violence can be referred. The Commission sees this big front door being a single access point to a multi-agency safeguarding hub or forum to which referrals are made for a range of concerns around susceptibility to being drawn into violence, including cases that show complex needs or unclear relationships to extremist ideologies or groups. Those at risk of becoming involved in terrorist violence would be passed to PREVENT and, if necessary, channel, while the needs of those where susceptibility to terrorism is not identified would be addressed by other appropriate agencies. To ensure appropriate referral, these forums would include a wide range of expertise, including those skilled at dealing with minors, severe trauma, violence fascination, and extreme fringes of internet culture. Counter-terrorism police would be involved in this triaging system, and where appropriate, referrals would be forwarded to PREVENT. This would not involve the creation of extensive new structures, but streamlines existing provision, avoiding replicating existing multi-agency panels. Further, it relieves pressure on PREVENT as a last resort for those seeking referrals from individuals about whom they're concerned by allowing appropriate direction to the most appropriate mainstream services without diversion via PREVENT. Indeed, extensive programs of work are already in existence in relation to serious violence, violence against women and girls, knife crime, and safer streets. We need, as the Institute for Strategic Dialogue put it, a sophisticated plan for knitting them together with a policy oversight board unifying all stakeholders and strong ministerial direction and interest. And then a little further down this page, please, towards the bottom. A multi-agency system to which vulnerable people can be referred should not reinvent the wheel, but build on existing successful local-level MASH models where the relevant professionals already work together or are encouraged to work together as part of VRU, PREVENT oversight boards, serious violence boards, and community safety partnerships. It must account for the inevitable variability in funding, quality of collaboration, and outcomes achieved from area to area. Not all new initiatives, such as Youth Futures or Family First, are equally available. The extent to which existing provision can meet the needs of adults, both the non-terrorist murders of Grace O'Malley Kumar, Barnaby Webber, and Ian Coates by VC, the Nottingham perpetrator, and the terrorist murder of Sir David Amos by AHA, was committed by adults known to local agencies. They will also vary considerably. And then, so at page 118, there are key findings and recommendations, and I just want to focus, for our purposes today, on the second and third and fourth paragraphs, please. This chapter has set out the argument for reforms to allow PREVENT to sit within a wider safeguarding infrastructure. This is necessary due to the increasingly complex and non-ideologically related cases coming through the PREVENT referral system, see Chapter 5. exacerbated by the recent surge in referrals for violence-fascinated individuals. While the latter may be dealt with temporarily by Prevent, the long-term need for the reconfiguration of Prevent into a holistic safeguarding system focused on the individual rather than the crime type is widely recognised. This tallies with the government's commitment to joining up public services. While requiring cross-ministerial strategic engagement and direction, it needs no extensive investment in new structures. Our proposals demonstrate how this reform can build on multi-agency approaches already working effectively in many local authorities in adjacent policy areas such as violence reduction, public health and children's services. Indeed, such reform could streamline existing provision, avoid replicating existing multi-agency panels and free up Prevent to focus on terrorism-related risk. This chapter outlines the system involving initial triaging through a multi-agency big front door. Multi-agency safeguarding hubs, MASH, are widely used already in local authorities, and restructuring to integrate safeguarding against radicalisation into terrorism would provide a unified structure for the combined expertise of those on the panels to decide the most appropriate intervention for individuals. Previous pilots, e.g. Dovetail, demonstrated the challenges inherent in such partnership models, where they include the sharing of sensitive data between MASH and counterterrorism police. However, the experience of Dovetail, which of course we looked at in our phase one, means these are known challenges which can be addressed at the design stage. Moreover, our evidence shows that alternatives such as police-led partnerships raise significant concern amongst local practitioners due to their covert nature, limited external scrutiny, and lack of transparency. In contrast, localised partnership-based approaches can transform counter-terrorism from a source of community tension into an effective collaborative effort. So that then leads to recommendations 19 to 23 from this commission. Over the page, please, at 119. 19, Prevent should be part of a wider local authority-led multi-agency safeguarding approach, with national government providing support to ensure consistency in standards. The government should explore ways to build on the success of Dovetail to work together with local communities to address concerns about risk management. 21, the government should explore how violence preventative work currently processed through the Prevent strategy and duty might be mainstreamed into broader violence reduction strategies. 22, moving to a multi-agency safeguarding model will require investment to rebuild capacity and support services in violence reduction, youth programmes and mental health services. And 23, the local government association should be supported by the central government to deliver a programme of facilitated peer support between local authorities as they design and implement locally appropriate multi-agency models. So that is, in very brief terms, the report of the Independent Commission on UK Counter-Terrorism Law, Policy and Practice. So would that be a convenient moment to take perhaps a 45-minute break for lunch?
It certainly would, Mr. Mawson. Thank you very much indeed. I'll sit again at 22.